camera on, and any other Zoom attendees, keep your video off. Can we please start the live stream? No mai haere mai to hui o te Komiti Arataki Māhiri Arohi, the District Plan Review Committee. Emergency procedures are on the screen. If you're not familiar with them, please take a moment to give them a read. But if in doubt, follow the lead of Judy. And we'll bring up the opening formalities onto the screen. Mea karakia tātou. Wait, sorry, that's the closing one. There we go. Tēnei o te haukai no nei o takutapawai. Ko te haukai nuku, ko te haukai rangi, ko te haukai ai tau tūpuna a tānei nui a rangi. Ka pikiti ai ki ngā rangi tūhaha, ki te tihia o manono. Ka rokohina atura ko I o mātua kori anaki. Ka tikinga mai ngā kiti o te wānanga. Ko te kiti tuari, ko te kiti tuatia, ko te kiti aranui. Ka tiritiri a, ka popo a, ka putu mai e ho, ko te I rā tangata, ki te whaio, ki te ao marama, tihei mauri ora. Moving on to item number 2, apologies. I received an apology from Mayor Barry. Are there any other apologies or lateness, early departure? And just noting Councillor Edwards is joining us via Zoom. So I'd like to move those apologies. Can I have a seconder? Councillor Briggs. All those in favour, say aye. All against. There you go. I would like to say for the round a little bit. We'll start with McCreary, who's speaking to item number 7 on natural features and landscapes, coastal environment, chapters and overlays. Please join us at the table. And you just push the button on the right-hand side. Just a reminder that you've got 3 minutes to speak, and if you can keep it a bit shorter, then we'll have some time for some questions. Kia ora, thank you, Don.
Okay, hello. I'm Don McCreary, owner and operator of Pencarrow Lodge. We recently purchased this 2.5 years ago with hopes and dreams for the property, and I find it really awkward here. I'm not a great speaker and things, but awkward that we have to come and defend our position with property that we've worked really hard for. Like, I've worked tirelessly for the last 20 years and got a leg up from my father and things, so he did the same thing, and now we're left defending the ability to use our private land and it not be made into, I suppose in quotations, a reserve or a parkland. So half of our property now, of a 200 hectare property, is looking to get an overlay over it from a strike on the map of outstanding national landscapes, which will restrict us hugely on the ability to freely go about our business and our on what we can do on the land. It's currently an operating farm and a lodge business with tourism operations. So, but the dreams and aspirations, me and my family, 2 little girls and partner have for that block. So, and it just seems there's only a few privately owned blocks. Few are here today that seem to be attacked because we are a minor. We're not the massive people, but we've worked really hard for what we own, and I thought that's how New Zealand operated. That we could get ahead and then have those dreams. So these overlays, I haven't prepared well because of course I try and I run 18 hours a day most weeks, trying to pay my rates and taxes. So I haven't been able to prepare on this. I feel if we're getting a major change through like this, we need a team given to us of professionals paid for by council or the public that wants these changes. to defend our position. It's very unfair that it's landed on individuals like myself and a few others. So, yeah, if I can just, from the little delving I've done into the research, which is tiny, into some of the factors, was policy 25 and what's that in the, sorry. Yeah, regional policy, thank you, statement. So that refers, one of the main concerns that refers to that there was to be consultation within the process of the mapping with the landowners. This has not happened until after the fact. So they've already drawn up the maps, and now we're left clawing our way back, trying to consult with them, and it's a very backwards situation. And so the word interpretation comes up in everything I've read. So there is so much left to interpretation. So if you take my interpretation from it, we wouldn't have any over our property. So and yet another interpretation would. So yeah, we might just have the sea faces in it. So it's a bit hard to elaborate to you guys, but the mapping is our property there. It runs back here. None of this is in it, which is actually more natural and got native, but yet all the productive farmland and lodge area is getting deemed to be hopefully you all understand, an outstanding natural landscape, and getting the overlays over it and the rules applied to it. So anything we had as productive and with dreams for and stuff is crushed. So yeah, thank you. Yeah, so 2.5 years ago, public and council and New Zealand had the ability to purchase Pencarrow Lodge, but I did. So if they wanted to make it reserve, they had their chance, and so please don't make it a reserve now on a private landowner and family. Yeah.
Kia ora. Thank you, Don, for coming in. Just a quick question from me before I open it to the other members. Is this the first time? So firstly, thank you for coming to the table and sharing this. Obviously, this isn't the best forum to have individual sort of property conversations about. I'm just wondering, have you already spoken with the team about your individual issues there, or is this the first time you've heard about it and coming to us?
No, we have spoken with it. I just thought this was the platform to, it's not about individual properties, it's about the whole system of this overlays with the RPS, is it, the regional policy statement?
Yep.
So I'm firstly, on a government level or the national level, this shouldn't have been put in the hands of, like shouldn't have been overlaid like this. Then secondly, the how it's been carried out by Greater Wellington, they'd set the scene for how it was to be overlaid, and now Hutt City Council, how it's being, I suppose, imposed on us. Yeah, so that's the greater picture of what I'm attacking.
Thank you, Don.
Yeah.
I've got a question from Councillor Edwards, and then Councillor Mitchell, and then Councillor Shaw.
Yeah, thanks, Mr. McCreary, for coming along, and you spoke very well, outlining your case. I'm just wondering, you talked about your ambitions and your dreams for your property. Can you tell us a couple of things, or what are you thinking won't be allowed if the overlay is put on there that will block you from, achieving these? What activities are you fear are going to be curtailed?
So the ability to build other structures on there and houses for my children in the future or myself. And then I'll be told that no, they're not stopped. There's regulations, but those regulations are so restrictive and expensive to go through. The extra consenting processes and things. This is just a little snippet of what I've learned over the last little while. So if we delve into this further, if I get lawyers and professionals to look over this, there's massive restrictions on us, and we aren't allowed to carry on farming as we know today in terms of doing the tracking required. That's all minimised now. The fencing, tracking, I believe any big operation we carry out, which is normal for our operation, is going to require consent and even a further process through that consenting process. So, yeah.
Cool. Thank you. Thank you.
Thank you. Councillor Mitchell.
Oh, I had the same question, Chair, but I'm sure our officers can speak to what those restrictions are when they speak to the paper as well. Thank you.
But Don, just so you know the process, and we take the public submissions now, and then our officers will come to the table and speak to each item. I think there's a fair bit of interest in item 7, so I'll probably propose bringing that forward to the start of the meeting, just so you don't have to sit around while we do the other items, but noting that a few other speakers are speaking to other items as well, so I hope that's not an issue to bring it forward. But then officers will address the questions that you are raising during this, and it may well be that they want to have a chat with you offline after the meeting to really get into the details about it. Councillor Shaw and then Councillor Briggs.
Sorry, I had a similar question as well to which Don's answered. Thanks for coming in.
Thank you.
Thank you, Don, for coming in today. Just wanted to check in whether you've been sorry, apologies, Chair, it's hard to hear when there's talking in the public gallery.
In the back, just to a minimum, it's quite hard to hear up the front here. Thank you.
Apologies, Don.
Yeah, it's very hard to hear. My husband's an excavator driver, so he's hard of hearing a little, and we can hardly hear.
Yeah.
And I'm good hearing.
If you want, there is a seat over here that does have a spare speaker on it. All the microphones have speakers on them.
Surely, as we pay for everything, could you not just turn the microphone up a little bit, please? That's all we're politely requesting. Please.
Yeah, unfortunately, it's not. We don't have access to turn it up. It's already at its max level. But Don, while the members are speaking, if you do turn your speaker off, then the speaker on your unit will actually broadcast what's being asked. So you might be able to hear slightly better while that's happening. But if everyone wants to just maybe use slightly louder voices, thank you.
Thank you.
Again, apologies, Don. Thanks for coming in today. Just wanted to check, and talking about yourself, have you been collaborating and connecting with other landowners that are also impacted by potential overlays as well?
Yes, I've been very fortunate with, Ken and Darcy and others contacting me to just, like, I believe I wouldn't have been aware of this if not, and it might not be due to councils notifying me in terms of an email and things, but I find that system very unfair that there hasn't been, like, I should be made to have response to it, to know that I got, it's a what is it, 7-figure situation for me, like the loss of what I'll incur from this, and for me not to get notified of this very early in the piece is very disturbing to my hopes and dreams going forward. I don't know if I want to be a landowner like too much longer, in the Hutt City region and furthermore, yeah. So, yeah.
We feel the same.
Thanks, Don.
Yeah.
Cool. Thank you. Any more questions from any members? No, thank you very much, Don. Obviously, you're more than welcome to join the meeting, and it's also being live streamed as well. So if you can't stay around for the whole meeting, you'll be able to watch it online later as well.
Yeah. Cool. So
Thank
yeah, just hopefully that policy 25 comes into effect and we start again and go through a consultation process.
Yep, we'll get officers to speak to the process.
And that we get professional help paid for to help us through this process, because we're very busy people that are trying to work hard and keep the country running, and then also that if it comes into effect, we are remunerated for our loss on the land. So
Exactly.
yeah, so cool. Thank you. Cheers. Thanks, everyone.
Our next speaker is Ken Jackson, who's speaking on behalf of himself and another landowner, Nigel Thomas, also possibly on behalf of Camp Wainui. Is someone from Camp Wainui here? Cool. So yeah, happy to give you a little bit extra time because you're speaking on behalf of another landowner. But if you can keep it to a minimal, that would be awesome. Thank you, Ken. can speak on items 5, Indigenous Biodiversity chapter, item 6, the rural zones, and item 7, the natural features and landscapes chapter.
Cool, thank you. I'll just read off this. I appreciate the opportunity to speak here today on District Plan Review. The topics I'd like to cover here are on highly productive land and the outstanding natural landscapes. I'll give you a bit of background as to why we are here today. I had read the original draft District Plan Review, which I submitted on, in which I was under the belief that the new government were putting SNAs on hold for now, and the Hutt City Council had also agreed to put it on hold. I thought this would have covered the outstanding natural landscapes as well. It wasn't until more recently that I realised that Hutt City Council were continuing with the outstanding natural landscapes. Eventually, I worked out how to search through the mapping and rules on the council website, and at this point, I realised that there were about 5 or 6 properties that were severely affected by these overlays. When I say severely, I mean close to 99% of some of these properties are covered with these overlays, and the rules are very restrictive, effectively stopping any future development and essentially devaluing our properties. I then contacted some of the other affected landowners, and not one of them had any idea that these overlays were proposed to be on their properties. Since then, we have had a couple of meetings with Tim and Nathan and Sean, who, to their credit, have been good to work with and are attempting to resolve some of our concerns. We understand that Hutt City Council was obliged to map these overlays through the RMA and the Greater Wellington Regional Council policy statement, but it clearly states in Policy 25 of the Regional Policy Statement that stakeholders, iwi and landowners must be involved in the identification of these areas. We don't agree that private property should be included in these overlays, but if council is legally obliged to include private property, then it needs to be done in a prudent and fair manner where landowners are fully included in the identification of these areas. I would challenge that anyone here today would be happy with anything more than a minor amount of property included in these overlays. We have some serious concerns about the mapping of the outstanding natural landscapes, which to us, it looks like it has been done on a blanket approach, which would involve a minimum amount of work for a large area without taking into account the true nature of the landscape. In Policy 25 of the Regional Policy Statement, it states that these landscapes need to be exceptional and out of the ordinary. I have got a few photos here which I could pass around if you... I've written on the basically what they are. And it just shows some of the areas that have been mapped and some that haven't, and some fairly random sort of mapping that doesn't make any sense. We would like to challenge that large amounts of our properties do not meet these requirements, but there are some areas that potentially could, and that we would be happy to protect them voluntarily. We are having trouble understanding why our properties have been almost fully covered in these overlays, of which large parts don't meet the criteria. Yet there are a lot of other areas around the Hutt Valley that would probably easily meet the criteria that haven't been included. In fact, I believe there is only 4 to 5 hectares of council land that is included in these outstanding natural overlays. Due to landowners not being included in the initial identification of these overlays, and our belief that the mapping is inconsistent and inaccurate, we would like the council to suspend mapping on private land until we have had proper consultation. Another point I would like to get clarification on is within these overlays, it states that iwi have customary harvesting rights. Could we please get the deferred terms on exactly what this means? Wow. And as to whether it should even apply to private land, unless there is very clear scientific or physical evidence for these rights. On the topic of highly productive land overlays, which affects most of the Coast Road and parts of Moores Valley, and in the unlikely event that the government haven't removed Class Land 3 from highly productive land, I would like to suggest a simple and a cost-effective clause to be included in the district plan review that gives a property owner the right to prove that their land is not highly productive. The reasons for this is that the mapping is old, inaccurate, and which I believe most officials would agree with, and also the fact that most of the Hutt Valley is clearly not highly productive land. There's another bit that came up. We didn't actually realise that SNAs were now going to be a part of this draft, as it wasn't included, I don't think, in the original draft.
Sorry, Ken, I'll just jump in there. SNAs aren't included in the district plan as we're proposing.
No, but
just-
there is some options in there, isn't it, to vote on?
No, SNAs are not in
Was that not on the
they're not in the
agenda?
draft and they're not in the proposed plan.
Not on the agenda at all?
No. But just to let you know, we are at 5 minutes, but I'm obviously lenient to let you have a
Yep,
bit more
not
time.
much to
But
go,
cool,
just about
thank you.
finished. Yeah, just going to say with the SNAs, I don't believe that, there's only a little bit on that. Prior mapping should be considered in the future resource applications or decisions on private land. I believe an incentivised voluntary system is by far the best way forward for SNAs and will create a far better biodiversity protection results if property owners are fully on board with it. Last little bit. We are all here trying to work towards a resolution that both protects the landscapes but also gives us the ability to sustainably utilise our properties. All of us are already protecting large areas of Indigenous biodiversity at our own cost on our properties. But to have this percentage of restrictive overlays is unreasonable and would be more than verging on a breach of property rights. Our properties are all suitable for eco-type tourism opportunities for a diverse range of people, but with these overlays in this present form, it would probably make it uneconomic and unsustainable. We look forward to getting your support to get this right. That's it. Thank you.
Good, I think Ken, I'll open up for questions. Any members got any questions? Deputy Mayor Lewis?
I just want to thank you, Ken. You've been coming in here for a few years now on this subject, and
Yep.
I just want to congratulate you for putting together the presentation today and providing those photos. They're very good.
That's it.
Kia ora, thank you, Ken. No further questions? Cool, we'll get officers to address some of those questions that you've raised during your submission. Thank you, Ken. Jane, are you ready to speak now, or are you still speaking on behalf of Craig, or did you want to speak? Cool. Do you know if Craig wanted to speak as well? Okay, well, yeah, we'll get through the submissions, and then if he pops his head back in, we'll obviously let him have a say. So Jane is speaking on behalf of the Wainuiomata Community Association on items 5, 6 and 7. Could Jane, you've got 3 minutes, and if you can leave a bit of time, then we can ask you some questions at the end. And if you just bring that microphone a bit closer down to your mouth, it'll make it a bit easier for people in the room to hear.
Oh, I'm sure they'll hear anyway. My voice is loud enough. I'm speaking via Craig on behalf of the Rural Association. I live in Moores Valley Road. I'll just read from my phone what he has sent me. 5 options for the ecosystem and Indigenous biodiversity chapter for the proposed district plan. These options are out of scope of the DP review document that we submitted on. This is a breach of process. SNAs are out of scope of this review, as I think we heard Ken say. The Hutt Council cannot accurately map the residential areas. These would have to be mapped at a very high detail. The staff claim that SNAs are out of date. It is important to recognise that they are never in date. They were inaccurate when they were first processed. 6, update on rural zones and the highly productive land overlay for proposed district plan. The staff have changed the summary of submissions. The report at an earlier meeting stated that the majority supported the subdivision. Hutt Council is still refusing to supply all the submissions requested under the Local Government Official Information and Meetings Act. A complaint has been made with the Ombudsman. Highly productive land overlay is supposed to be geographically consistent and meaningful. The government has signed that the criteria will be changed. 7, update on the natural features and landscapes and coastal environment chapters and overlays for the proposed district plan. These areas are not consistently applied. Almost no Hutt Council land is included. This is a land grab.
Exactly.
The Hutt Council, Greater Wellington Regional Council, land above the East Harbour coastal area is not applied to the ridges. This is an area visible to capital city that is covered in mature nature forest. Why is the whole of the bush area visible to the seaward side not being put up for protection?
Wow.
Why are private lands not visible to the residents of Hutt being put for protection? Thank you. Proposing these areas of ONL and ONF based upon a report over 10 years old is not consistent with the position in the 218 SNAs. Now, that is a report from Craig Innes, the chair of the Rural Association. So, and I couldn't have put it better myself, and I really feel that these strong words, they're actually being listened to by the council, by Wellington Regional Council. It just makes sense to actually, ratepayers who pay for the council's work they do are being disqualified, being bullied by an association, council association that could just get together with these landowners and be a little bit more reasonable, as Ken said. So that's what I've got to say.
Kia ora, thank you, Jane. Have you taken the opportunity to speak with our officers before the meeting about your individual property and what's being proposed or not being proposed there, or is this the first time you're raising those issues?
I think I've raised it before, quite a few times,
Okay.
with the association and by myself. I don't know. I don't sit on my hands all day, so I've got other things I've got to do.
Cool, thank you. Do any other members have any questions? Councillor Mitchell?
Yeah, just a question about the significant natural landscapes overlay. It sounded like you actually think more landscapes should be identified and protected. Anything visible from Wellington City?
Could you flick your mic on, Jane? Sorry, we just can't hear you and it won't be recorded.
That's not what I said at all.
No, well, it wasn't you that said it, it was Craig Innes, but what I heard
It
was
wasn't. Craig didn't say that at all either.
greater area of East Harbour Regional Park and something about the western hills of Lower Hutt. Those are areas that aren't currently included, so to include them would be a greater area identified and protected.
Council, yes, council's area.
Exactly.
Because let's face it, you give and take. The council can't keep taking. You've got to work with these things. The council got to use their own area as well as asking landowners to use their area. It's just fair. It's democracy. Are we living?
No, we're not.
And are we actually now going to be living in a?
Autocracy.
Yeah.
Sorry,
like
point of
in
order.
Russia.
Sorry, Jane, to cut you off. It's continually hard to hear the members of the public speak when there's interjections from the public gallery chair.
She's just agreeing. We're also really upset that that we're having to actually
Sorry, Jane,
enforce each
sorry,
other's.
Jane, just pause you for 2 seconds. If we could keep the comments in the public garage to a minimum, I think you're speaking in a moment. If you're not, you're more than welcome to come to the table and share your thoughts. That's totally fine. But you are interrupting Jane's submission.
Well, I agree with her, so it doesn't matter. I just feel that, you know, the council can't just keep taking. Got to work. What makes a circle go round? It goes around because there's no interruptions in that circle. And at this point in time, there's no circle at all.
Cool. Thank you,
It's
Jane.
just-
Are there any other questions? Councillor Mitchell, thank you.
The overlay expanded to include some of the areas identified? Okay, thank you.
How about we change, I come to you chair, you come to my chair, and I tell you exactly what you're trying to tell me. Just swap.
Sorry, I'm just trying to understand your submission, which made the point that the certain areas weren't covered, and it sounded like you wanted them to be covered. I just want clarification of whether you do or not.
Well, that's just what I've said. You know, why doesn't council do more of their areas? That's what I'm telling you.
Please clarify me if I'm wrong, but what you've said is reduce the private land thing, and you haven't even included the public land.
That's what I'm saying.
Yeah, which is
What you said to me. So, like,
thank you, which is
Can you understand
what I'm
what
trying to
I'm
clarify.
yes, so,
Okay.
so is that right? Yeah. All right.
Cool. Thank you. Were there any further questions? No, thank you very much, Jane. If Craig can make it back in and wants to add anything, then he's obviously more than welcome to, but it does sound like he's a bit preoccupied out there. But yeah, thank you for taking the time and coming in and speaking on behalf of the Wainui Rural Association.
Okay.
Our next speaker is Darcy Clark, who's speaking to item number 7, Natural Features, Landscapes and Coastal Environment Chapters and Overlays. Darcy, please join us at the table. I think the microphone's already on there. And as I mentioned at the end, I think there are more people in the gallery than we've got written down. So if anyone wants to add anything or agree with anything that's been said at the end, I'll open it back up to see if there is anyone else wishing to speak. Kia ora, Darcy, thank you. You've got 3 minutes. If you can leave a bit of time within that for questions, that would be great. Thank you.
We actually have got 6,000 acres, so I'd like to have about 3.5, 4 minutes, and I think our area probably represents that time. So I'm Darcy Clark, representing Orongoronga Station. We have been the landowners of this block since 1985. We firmly believe, in part, the assessment of our ONL is based on personal opinion, not qualifying factors. Carbon Crop and MPI have mapped our land for the inclusion of 1,815 acres in the ETS system. Much of our land missed out on this based on not being established well enough vegetation. The qualification of much of our land in the ONL states, and now this is from the council and the document, our land does not possess all the important factors within our localised area, but it does form part of the bigger picture within the wider landform and landscape, i.e. not on our property, but from land which has been identified as having these factors on neighbouring land. Council tasked one landscape architect company with mapping this. This gives only one point of view. So if I ask 10 companies to map this, around New Zealand, with the inclusion based on the bigger picture, how far would this reach and how many opinions would differ? We have 6,000 acres, of which 5,740 acres are mapped under seriously restrictive overlays. The disappointing fact is we understand a lot of the mapping and the rules. which some rules are being modified, but very slightly. And as the person with the rules would tell you, there's just not much scope to alter them. But thankfully, they are trying a little. But we would still be required to apply for consents. Some mapping and rules would not even allow this in a lot of areas. This would accompany extensive cost with no guarantee of success. Is council prepared in writing to waive a consent and professional cost? Then maybe we would agree to the ONLs and mapping rules. Council have indicated our inclusion in the ONL is based on the bigger picture in a lot of our areas, and they believe this is sufficient. This disappoints us as we figure if approximately we were given another 290 acres, and this was carved out at the bottom of hills on flatter, grassier, low-value scrub land, we could work with this going forward, as approximately 90% of our activities and business opportunities are within this area. In discussion with council, as of yesterday, Tim, and I must say Tim's been great to work with. I know, look, he's trying, but basically in his words, he has said if this was a negotiation, we could negotiate, but it's a scientific review that said, bang, we're in it. That's it. We don't believe it would affect the pristine state of this area, which we have achieved to preserve. And I have had so many people visit these areas, including professionals, who are blown away, as this was grassland and farmland in 1989 and 90, which we have photos of. And as for the hill features, because it's not just about vegetation, I think if you cleared every hill in the Wellington region, they would all pertain great features. There would still be 5,450 acres of our land with heavily restricted mapped areas and rules. If we could get the 290 that we need to work with mostly. There is no remuneration, there is no rate reductions. To set a precedent of late, there has been a boundary change to help us. It is 10 acres that a 12-year-old could have drawn around our houses. The grassland behind it and the pines have not even been included. Due to our lack of consultation, as of yesterday, we have now engaged the expertise of a lawyer in this field, which my sisters rung this morning and sent me the name of, and this is their field. Through a friend of ours who's a geologist in the South Island, he has put me on to Federated Farmers through the lady he's dealt with on these matters in the South Island, as he managed a lime quarry and had these issues throughout time. So we're finding the task group, because he said there will be one that deals with this policy. He has also got links with a suitable landscape architect who is aware of this type of ONL, based mainly on the fact that our inclusion under the bigger picture assessment gives us grounds. We believe this is our only avenue now. We are astounded at the reliance of the narrow view of the process above the outcome we could all achieve if we work together more. Thank you, that's all I've got.
Kia ora, thank you, Darcy. Any questions from any members? Councillor Mitchell.
Thank you very much for your submission. You're not the first person today to talk about a lack of consultation, but also name the officers that you've been talking to on some kind of basis. So what is the nature of the consultation you feel that isn't going on already?
Well, the consultation's been great, but the yardage we get out of it is non-existent. That's the point. They've been great. The people we've consulted with are great, but we're not getting any mileage. Basically, you'd agree, Tim? You said to me yesterday that if it was up to you and it was a consultation process and give and take, you would work with me much more, or us. But basically, it's a scientific study that just says, bang, that land's in it, that's in it.
Yeah, so the
Correct?
process has been explained to you quite clearly as part of the consultation.
Yeah, we've actually been sent it in an email why our particular block, and that stuff that I wrote down is actually the basic summary of why we were included. Yeah, and we're happy to include a lot of our land. We've let it, we've got ETS, 1,815 acres. And we understand the coastline and we're just trying to work with the rules a little bit, but we understand that it needs to be protected and that's the way it's going. But up in the guts of our land, which is the ONL, this is where it doesn't meet the criteria. It's not seen by anyone. It's internal in our gully, and this is where our operations would be. And there's a lot more than the land that we're asking for to operate on and not have these restrictions, because these restrictions come with huge costs. They say, yes, you can apply for consent, but do we really need to for the operations? And I've done a site visit showing our operations. And I know a lot more land than what we're asking for doesn't meet the criteria, but we're not asking for that because we've let it revert back. We're just asking to be worked with.
Kia ora, thank you, Darcy. Before I go to Councillor Shaw, just a quick question from me. So you said that you understand the mapping and the rules and that some rules have been slightly modified, but there's not much scope to alter them. Is your biggest concern primarily the financial costs for the resource consent if you do need to go through that process?
Yeah, for sure, because a lot of the activities we are looking to grow going forward and some of the existing stuff to expand it would need consents that don't need consents now. So there would be huge costs to that, and some of them we may not succeed in. I know in talking to Tim yesterday, you can approach council and they may say, well, it's not worth applying for that. But in some of these areas at the moment we can do, and it's pretty minimal work. But on the other hand, there's grey areas that they couldn't give an answer on if we applied for consent, and we may lose. And these professionals aren't costing less. We're going through a consent now that I took a urban planner out, and she's seen how simple it is, but the rules, she said, would possibly cost us 50 to 80,000 to get consent under the current rules. But it's so simple, she's actually going to get regional council out because she believes they should be able to work with us because it doesn't need all the professionals. But the way it's written at the moment, we need them because that's just a blanket for everybody. And so this is just an example of where it's heading.
Cool. Thank you. Councillor Shaw.
You actually answered my question in part. So just that I am getting this right, you've suggested that it's a personal opinion about these overlays, that the scientific review doesn't cut it, and that you were going to bring in federated farmers to help with a description of the overlays. And my suggestion was going to be about if regional council had been involved in these discussions as well. And I think you've just mentioned
No, because it's not a regional council matter. I was just giving an example of a regional council consent we're applying for at the moment. So this is a Lower Hutt City Council issue. But going forward, the consents are going to be under a similar process. I can't remember, you made a point that I wanted to answer, but no, and when you said before about me believing it's personal opinion, I can't remember what you said after that, something about...
Oh, the scientific review.
Yeah, I believe the scientific... No, the council wrote that our land doesn't all meet the factors. Sorry, when I say the council, the professionals, this is their words, not my words. And yet they've just gone, in the bigger picture, you're in it. And we find that hard to believe. And that's all we're asking for, but a work on it, you know.
Thank
you. Kia ora. Any other questions from any other members? No. Thank you so much for coming in, Darcy.
Thank you.
Kia ora, Julie. You're welcome to join us at the table. If you just push that button on the right-hand side, that'll turn the microphone off. And if you can't quite hear us, turn the microphone off when we're speaking. It'll make it a bit easier for you to hear us. You've got 3 minutes, and if you can keep it short on that, then they'll leave some time for questions.
Okay.
Thank you.
Thank you. I actually wasn't coming to speak to it today because I didn't really realise that this was still going on. I came to the council, it was some months ago, to see what was on my property, what sort of restrictions are on my property, just so from my own point of view. And they brought out an old map and said to me that all these SNRs are still on my property from ages ago, but they have no legal pertainment at all. So I don't know what they're doing there. That was all supposed to be taken off after the sunset clause. Anyway, I went off home, and then a few weeks later, someone called me from the council and said there is other stuff on my land. And so he sent me a copy of it, and it happens to be outstanding natural landscapes and outstanding natural features over 50% of my land, which is 3,500 acres. Now, I've been on that land for 20 odd years now, and my late husband went to court over this with the sunset clause, and it also had exactly what's on here, and he spoke to the judge about it, and the judge said it was ridiculous. So you people have just come back after, well, the council, not you people, after 20 odd years and done exactly the same thing. And we've been battling this. My husband's now dead for 6 years, but we've been battling this for the 20 years that we've been on this farm. And it just goes on and on and on. And I got asked by the council officer, they were very good to me, and they said, would I like someone to come out, or whoever the person was that mapped it, to come out and have a look? And I thought, no, I don't, because there is no outstanding natural landscape. It's all scrub and bush. It can't be seen from Wellington. So I don't, that was what they said the first time around 22 years ago. I mean, all this is factual. It's all in court case. And I've got it in boxes at home of all the stuff that we've been through with this council over this land. And I don't know, we always thought it was because we're between the Regional Council Park and the Hutt City Council Park. And we know they want this land. Well, John McCleary's probably in the same spot. I mean, I've got books of what the Hutt City Council's written and what the Regional Council's written, and it says they want this land. And if they think they're going to take it by doing this to me, well, I'm sorry, I won't put up with it. And it will be a legal case. So that's all I want to say.
Kia ora, thank you. I know you said you were speaking on item 7, which is the natural features. Have you had a chance to read item 5, which does talk specifically about the SNRs?
No, Craig only sent me an email to say this was on 2 days ago, and so I quickly read it and I didn't take any notice of the SNRs because I thought they'd gone.
Yeah, so the recommendation in the report today is that, I'll just read it out so I get it exactly right. Under this option, the SNRs will be amended to only identify SNRs on public land to ensure the proposed district plan to remove the confusion created by the mapped areas where rules don't apply. So the court case you're referring to said that the rules and the policies now no longer apply to SNR land on private property.
Yes.
The proposal is actually to remove the SNR entirely from
right.
that property just to remove that confusion.
Yes,
and
that's
also some of the
fantastic.
flow-on effects that occur from national policy statements referring to SNR land. This kind of removes all that confusion. But the ONFs and the ONLs are a completely separate mapping
I
exercise. They're
understand.
nothing to do with the SNRs, which we're proposing to remove.
But the ONLs are something that was put on same time 22 years ago, or 21, I'm not sure. And that's what my husband went to court about as well.
Cool. We'll get officers to speak to that particular issue when they join us at the table shortly. Do any members have any questions? No, thank you so much for joining us,
Thank you.
Julie. Cool, thank you. Jane, do you know if Craig wanted to speak? Cool. Do you know if Craig was wanting to speak? No, cool. Were there any other members wishing to speak or agree with? No. Cool, awesome. Okay, well. No, cool. Okay, we will move on then to item number 4, conflicts of interest declarations. Do any members have a conflict of interest to declare? Councillor Edwards?
Yeah, there's been a bit of discussion and mention this morning of federated farmers, and I have other employment with federated farmers. So I will not, I'm not sure whether I am conflicted, so I'm going to get some legal advice later on this, but in the meantime, I will not vote on either of these chapters.
Kia ora. Thank you, Simon. Cool. Did want to also acknowledge that we have received a written submission from Dan Jackson, which has been circulated to us previous to the meeting, which we've all had time to read. So that will go into the minutes of the meeting as well. Thank you, Dan, for making that submission. Were there any other conflicts of interest? No. Cool. Cool. We'll move on to our officers. Okay, if we shuffle the order around and bring item 7 forward. Cool. We'll move on to item 7 then. Just in the interest of most people being most interested in that. Cool. So please welcome Tim Johnson, Head of Planning, to speak to the item. This is page 26 of the agenda. So just to make it really clear, we're going to do item 7 first, because that's what the topic everyone spoke of, and then we'll go back and do items 5 and 6. But obviously, you're more than welcome to stay for the whole meeting.
Kia ora everyone, and if I can just introduce Emma McRae from Boffa Miskell, who is our landscape expert helping us, and I might call on Corinna Tessendorf from Urban Edge behind us, who is also assisting us with this work. I'm happy to take the paper as read, but I will make some opening comments just in response to points made, and I think there's some stuff to talk about in relation to the mapping process, but I might leave that till the end and cover off a few points first of all. In relation to the rules and the restrictions in place, yes, there are new rules in place, but there is a resource consent pathway, so there is nothing that is prohibited from happening apart from mining and quarrying in certain parts. So that is the one activity that there is a prohibition on. But there is a consenting pathway, and if the application is made and can be shown to respect the values of the area, then there is every opportunity for that consent to be granted. And we offer pre-application service, and we can help people through that process. There was comments made about remuneration and waiving fees. That would be something that the council would need to decide on and provide guidance. That's something I cannot provide guidance on today. There was points made about other areas that haven't been included, and potentially when we talk about the mapping, we can explain why other areas haven't been included. But look, I mean, in reality, when the plan is notified, if people want us to relook at those areas, then we can through the submission process. So if it feels like it's unjust, then if we get submissions, we can relook at those areas. So that is an option for us. There is parts of public land that is included in the outstanding natural features mapping. There's parts of Hutt City Regional Council and Dockland, but I'm not underestimating how much private land is also covered. Darcy referred to conversations we're having. I just want to echo those are real. Effectively, we are trying to work with landowners, but the point is we are working under a statutory criteria and context, and so we are bound by that, but we are having conversations as much as we can. I think those were the main points I wanted to cover. I'm sure there'll be more questions. In terms of the mapping process, we commissioned Boffa to do this work, I think, in 2018, so there were no outstanding natural features or landscapes. 2016, apologies. Coastal landscape. So I guess my point there is, just in the submitter's last point, these haven't existed before that time. That is the process when these were identified.
Sorry, I didn't quite catch what Emma said. Would you be able to just flick the mic?
Sorry. Oh, I did click. Oh, there we go. Okay. Sorry. I was just confirming that the Hutt City Landscape Evaluation Report, which is the background to the outstanding natural features and landscapes, was prepared in 2016, and the Hutt City and Wellington City Natural Character Assessment, which is the background to the coastal areas, was prepared in 2018.
Cool, thank you.
And apologies, just the relevance of that point is they haven't existed before that time, so there might be a bit of confusion between SNRs and the outstanding natural landscapes. In terms of the mapping, Emma can talk about kind of the process, but effectively the consultation, the main consultation tool was the draft district plan, as the committee will remember when we sent out 7,500 letters to residents across the city. We received feedback on all parts of the draft district plan, including the outstanding natural features and landscapes. Where we have been asked to carry out site visits, we have carried out site visits by landowners. We have made some small changes as a result of those site visits, and we have been in discussions with some of the landowners that have led to some of the changes. So that's effectively the process from commissioning Boffa to producing the draft, to site visits, to making changes, and of course the next process will be notifying the plan when there is a chance for this to continue to have these conversations and further opportunities for site visits post that time. Did you want to talk a little bit about the mapping, what's involved in the mapping now? Is that?
If that's what people would like, if that would be helpful. Yeah, I guess, do you want me to give an overview of that process and how it was carried out? So it is, I know you're provided with that evaluation document as a background. On page 7 of that document, it's got a little flow chart that breaks down what was done. I know it's a big document, you probably haven't had a chance to look at all of it, but that's just what I'm referring to. So the process to undertake that O&L mapping was looking at the relevant data and overlays, first of all in GIS, and then understanding data gathered from kind of local knowledge, previous field work that had been done, and expert opinion of landscape architects, and that looked at a first cut list of candidate sites. So originally there were further areas within the city that were looked at, that were put under consideration for being considered to be either an ONL or an SAL, a special amenity landscape. So that Hutt City evaluation also identifies special amenity landscapes, which includes quite a number of areas like parts of the Western Hills and things like that. They were found, those have not been taken forward into the district plan, so they were identified in the study as being special amenity landscapes, but they did not meet the criteria or the threshold to be outstanding natural landscapes. So that's just a little bit of context there. Then after that, there was a meeting with Hutt City officers to confirm those candidate sites. And then the evaluation of those candidate sites was based on an evaluation of the criteria, and the criteria for doing that are in policy 25 of the regional policy statement. So it's looking at the natural science, sensory values, and shared and recognised values. And in order to qualify as an outstanding natural landscape, they have to score high or very high against 2 of those criteria. So the bar is quite high in order for a landscape to meet that criteria. And because we're talking about landscapes, it needs to be of a landscape scale. If it's a smaller area with values, that's been identified as a feature rather than a landscape. So there's some features in some landscapes, but principally what people here have been talking about today is the landscapes. Then the next stage, is to evaluate against those thresholds, confirm and calibrate the evaluation scores and weightings and the extent of the site. And that was done in combination with the council officers. So there was an evaluation that was undertaken, and there was a series of workshops that were held with council officers who were working on the project at that time. And you know, the weighting and methodology and things like that were discussed with them. And that eliminated sites that didn't score high enough to receive the ONF, ONL or SAL distinction. So there was a bigger lot of areas that were looked at, and then that was refined down. Then there was some field assessment undertaken to refine the boundaries from what was able to be done based on public viewpoints, essentially. It wasn't visiting private land at that stage. And then finalising the descriptions and the mapping, which is what went into the report, and then it was issued as a draft report to Hutt City to review. And in the report, it acknowledges that as part of the process of this going into the district plan, that there would be opportunity for refinement of those boundaries. So because, again, talking at that landscape scale, they're mapped at a scale of 1 to 10,000, and that is because of a necessary landscape scale, but also trying to map areas at a district-wide scale. You don't have the ability to go to every single place. It would be too cumbersome and unreasonable and expensive for the council to do that. So you're doing it, at a fairly high level, but there's opportunity for refinement, which is what we've been doing now with the landowners. So several have mentioned that we've been and talked to them, and there have been some boundary refinements that have been suggested based on site visits that we've undertaken.
Cool. I had one question just on that sort of boundary refinements. One of the speakers Darcy mentioned about that he would be relatively happy if there was a sort of a carve out of those lower parts of the hills, which is where 90% of his activities happen. Is that something that is physically possible to carve out at this stage, or does that have to happen through the notified plan change process to actually be carved out?
So in relation to Darcy's land specifically, myself and a colleague, we actually spent the day with Darcy and we've been around quite a large extent of his property. And what we looked at there was we considered, there's a carve out that's been considered around the area where a number of houses and buildings are. So we've undertaken that mapping. I would say the rest of those areas are kind of consistent with it at a landscape scale. And if you start sort of carving, and that piece is at the edge of the boundary of this landscape, if you like. So there's some logic there for being able to exclude it because it's not exhibiting the vegetation cover and the patterns and the other things that are contributing to it perhaps being part of this ONL. If you started carving out little bits at the bottom of a valley, that's sort of that's part of the landscape, if you like. So I find that harder to justify. I'm happy with the review that we've undertaken and looking at the consistency of what's there and that it meets those threshold and the criteria.
Thank you, Emma. Do any members have any questions? Councillor Mitchell? Sorry, Darcy, we're not allowed to allow questions from the public, but if you want to stick around, I'm sure Emma will be able to answer a question, or if it's a question to me, you can definitely speak after the meeting. Councillor Mitchell.
Thank you. Thanks, Emma. One of the things that was raised in public comment was whether or not landscapes or parts of landscapes are visible to people from outside the property. So how does that weigh into the assessment of whether a particular piece of land is part of a significant landscape or not?
That forms some consideration, I guess, in terms of those shared and recognised values. Like if people can see it, they're more likely to, particularly those landscapes that are visible from public places. So several people mentioned about, the Western Hills should be in because everybody can see it. So there's obviously values there that people recognise, but it's not just about visibility, and it's not just about, I guess, those shared and recognised values. It's got to be balanced with the natural science values. So they've got to have quite high, the quality of the landscape that's there needs to be quite high and, relatively unmodified. So it's not just about whether it's visible or not. There's other factors that weigh into it.
Thank you. And one of the areas that was mentioned in public comment was East Harbour Regional Park, and I think there's a bit of confusion about that one. Just looking at the maps, it does have a coastal natural character overlay, but not an outstanding natural landscape at all. I was just wondering why an area like that, which as was mentioned is quite visible to people from Wellington City even, but from around the region, why did that not meet the grade for an outstanding natural landscape?
Specifically that one, it would be in relation to the land cover because the East Harbour Regional Park is quite modified and a lot of it is just, there's not a lot of native vegetation cover, it's quite open, it's quite modified. I think there's outstanding natural features that are identified within the park, so again it's probably to do with the scale and the landscape scale of it. Parts of it I think are a feature, but it's not a landscape.
Sorry, just specifically too, I'm talking about the northern part of East Harbour Regional Park and behind Eastbourne and Days Bay, the actual remnant forest part of it.
That part, oh, yes, okay.
Sorry,
so you're talking about the hills behind Eastbourne, not the bottom bit.
Sorry, yeah.
So that was identified as a special amenity landscape. So what I was talking about, again, it wasn't quite of the quality where it met the outstanding. It didn't meet outstanding, so it obviously didn't score. It might have scored highly for, certain values, but not enough to be considered an ONL. And yeah, the background to all of that is in that evaluation report. So if you had any more questions about that, I'd advise having a look at that because it gives you all the background about what the values are. And
Sorry, we don't allow questions from the public, but you're more than welcome to stick around after the meeting and then.
Yeah, sorry, a point of order, Chair. This has been ongoing since the beginning of this meeting. There's been constant disruption from the public gallery, and we cannot participate and hear the officer's advice. Can you please ensure this doesn't continue?
Yeah, thank you. We are trying to take officers' advice here and we are struggling to hear them. So if you could please refrain from talking in the public comment. There's room outside if you want to have a conversation, that's totally fine. If you've got questions of any members or myself or the officers, we will be here after the meeting. We're not going to go running out. So just keep hold of your questions, but please refrain from talking so much because we are struggling to hear.
Thank you, Chair. I think my question's been answered.
Were there any other questions from any members? Deputy Mayor Lewis?
Thank you. With the assessment that was done, the Boffa-Miskell one, have the rules changed since, like, the government's made changes to what we've got to assess now? Are they different, the assessment to what we're having to assess, or are they both the same?
I can't, no, essentially no. I'm not sure why you think it's different, because it's based on, you know, what's in the RMA, which is what we're still operating under, and what the regional policy statement says. And so if we were doing it again today, we'd still be referring to those same documents, because that's what we're working with.
All right, thank you.
Any other questions from any members? No, cool, thank you very much. We'll move on to the recommendations. So we are on page 26 of the agenda. I would like to move that we note the contents of the report and direct officers to complete the natural features and landscapes and coastal environment chapters and overlays for the proposed district plan. Do I have a seconder? Councillor Mitchell. I'll speak briefly to this. Obviously, we are just signing off the proposed district plan here today, which will now go out for consultation. It'll be signed off later this year and then go out for extensive consultation, which will take 2 to 3 years. It's a very long process with the plan change. We've had the beauty of a lighter touch consultation through the draft district plan, which has allowed for some modifications to what is in front of us today. That was the whole point of that process. But obviously there is now a process to go through with independent commissioners who will assess all the information in front of them to make a decision based on what their interpretation is of the RMA and the RPS. Were any other members wishing to speak to this item? No, I'll put the motion then, just noting Councillor Edwards isn't taking part. All those in favour, please say aye. All against? I declare that carried. We'll now move on to item number 5, which is on page 8 of the agenda. I'd like to welcome Nathan Good, our Policy Planning Manager, to speak to the item. So this is the options for our ecosystems and Indigenous biodiversity chapters for the proposed district plan. Nathan, we've obviously read your report. Is there anything you'd like to highlight?
No, I'm happy to take the report as read.
Do any members have any questions? Councillor Mitchell.
Thank you. Just a couple of questions about this one, and just acknowledging for clarity that we're not going and recognising SNAs, even though there's a comment in there that the regional policy statement, I think, effectively requires us to identify SNAs. So my first question was about the hierarchy of things, because the government has signalled that we aren't required to do that, not for the next 3 years anyway. It's all on pause. The regional policy statement effectively requires us to do that. We know that we don't have time to do that actually, and that it's not being done, but just for the clarity and maybe for the public gallery as well, what's the order, the hierarchy and the order of things when you have documents which are essentially conflicting with one another?
So the standard hierarchy of documents under the Resource Management Act is you have your national policy statement, which is set by central government, and there's a requirement for district plans and regional policy statements to give effect to national policy statements. The next tier down is your regional policy statement, which is set by the regional council. And there's a requirement for district plans and regional plans to give effect to regional policy statements. And then kind of the final tier is where we get down to the district plans and the regional plans. With the district plans, so I guess in summary, the requirements for them is that you need to implement both your national policy statements and your regional policy statement. Sometimes there can be some inconsistency between those, and an example would be if a national policy statement said to identify these areas. And a clear conflict like that, you would look at your national policy statement as the, I guess, the highest order thing, and the regional policy statement should be amended over time to give effect to that national policy statement. I should say with the pause of identifying significant natural areas, that's still a bill that is going through the parliamentary process, and that bill hasn't been made an act yet, so that pause hasn't actually taken effect yet. It seems highly likely that it will, and it's just a matter of going through that process. But that does just address the requirements to identify significant natural areas under the national policy statement. It doesn't remove any requirements from the regional policy statement. And I think I go into in the report that that is still a live requirement, technically, for council to do. However, there's not enough time between now and notification of the proposed district plan for council to go and do the community engagement, the on-the-ground assessments, the engagement with mana whenua. There's not enough time to do any of that before we notify the proposed district plan. So that's why my advice is that there shouldn't be SNAs in the proposed district plan. That work takes some time, like even 12 months would be optimistic. However, my advice is that, I suppose, two things, is to address the ecological values on public land, particularly in areas that are in the natural open space zone. So those are areas that are public space, and they are areas where the objective for the zone is about protecting those ecological areas, the Indigenous biodiversity values, and they're typically regional parks, Remataka Conservation Park, and other city council land that is already highly covered in vegetation, native vegetation, but also to direct officers to include a work stream so that we can keep on top of whatever those changes are to the national direction and the regional direction, so that we can show that while technically we haven't identified SNAs, that we're not trying to wash our hands of whatever our legislative requirements are, but that we are undertaking the work necessary to meet the legal requirements, but also adapt to whatever those changes in legal requirements are.
Councillor Mitchell again, and then Councillor Shaw.
I'll just squeeze in a couple more because they're on the same theme. And one of the things you talked about was public land. In 2019, when this council, or Hutt City Council, decided not to, or to pause its SNA work, one of the commitments then was to introduce a plan to protect and enhance all SNAs on publicly owned land. And I'm only talking about publicly owned land here, just for clarity. The recommended option in front of us today includes protection of Indigenous vegetation on public land in natural open space zone, replacing the SNR approach. In your mind, does that meet the commitment of this council from 2019 to protect SNAs on public land?
In my mind, it does. There is other public-owned land that isn't in the natural open space zone. There's also land that's in the sport and active recreation zone, but that's land that's clearly for the purpose of active recreation. It's, you know, it's your rugby field, your soccer field, your, you know, they are parks, like Avalon Park, like they're parks where people are going to be playing. And same with, there's one that's a zone that's the open space zone that tends to be for like your neighbourhood parks, your playgrounds. There are also areas that aren't set aside for Indigenous biodiversity. There's also other work that council does outside the district plan, obviously through its parks team and through working with Department of Conservation and Regional Council to try to work together, I suppose, in protecting Indigenous biodiversity. Should say that it wouldn't mean that you can't do anything, or the councils that this would apply to wouldn't be able to do anything. This would still be provisions that provide for the maintenance of existing tracks and buildings and the things that you kind of need to have within those sites to enable the enjoyment of the values of those sites.
Thank you. And just finally, if I may, there was something that arose after that decision in 2019 and was mentioned today in public comment, which was people who want to protect their land voluntarily. With these recommendations today, is there a mechanism, will there be a mechanism in our district plan to support landowners who want to protect their land? For example, could they request a natural open space zone overlay on a small piece of land, or does it only apply to bigger pieces of land, that one?
There's nothing stopping a private landowner from requesting that their land be zoned to natural open space. I don't think there's much value in doing it, but absolutely they could. But if someone has a piece of land that they want to protect from development, then if it's their land, then they have full ability to do that through some sort of covenant. QE2 trust covenants are the ones that people often turn to in those situations.
So that would be our recommendation. Maybe a QE2 covenant is the best and
that'd be my
most
advice
robust way of doing it. Yeah, thank you.
Councillor Shaw, then Councillor Edwards.
Thanks, Nathan, for the report. I'm just thinking about the hierarchy that we just talked about, and you didn't mention the Resource Management Act, which is currently undergoing reform at the moment. Is that part of the hierarchical system? Does that sit there? Does that affect any of the other policy statements?
Oh, yeah, I probably should have mentioned that above all of the national policy statements and the regional policy statements, and then our regional and district plans, is the Resource Management Act. That's kind of it's the top tier. That's the document that requires allows the central government to prepare national policy statements and tells central government how to do that. And it's also the document that tells regional council how to prepare the regional policy statement and how the city council is supposed to prepare the district plan. So all of those other documents are ultimately trying to achieve the purpose of the Resource Management Act, which is sustainable development. So that is more sustainable management, I should say. So that is the top tier.
And the fact that it's currently under reform, how does that affect our decisions now and for the district plan moving forward?
It's certainly something for the council to be monitoring exactly what those reforms end up doing. We've had some signals from central government about what the reforms might involve, but the council's legal requirements still sit in the Resource Management Act. They don't sit in the legislation, which we've heard there'll be a draft or maybe even a bill of sometime next year. But it's the Resource Management Act that sets the current legal requirements.
Councillor Edwards.
Yeah, thanks, Nathan. Really good explanations. And just sticking with this hierarchy question, regional policy statements have to give effect to national policy statements. But as I understand it, there's some circumstances where regional policy statements, as long as they're giving effect to NPSs, can go harder on some aspects, like regarding the NPSs as bottom lines. And I'm just wondering, the Greater Wellington Regional Council has just put out Plan Change 1 to its RPS, and it does seem to go harder in places. What are the ramifications for the chapter with that plan change for the chapters we're talking about?
Yes, so a regional policy statement only needs to implement the national policy statement. It can go further in some situations. It's only if the national policy statement prevents the regional policy statement from going further that it can't. You're correct, the Regional Council has recently gone through a regional policy statement change process, RPS Change 1, that would introduce some new requirements into the regional policy statement for the identification of SNAs. The Regional Council made its decision on that change last week, but those changes don't yet have legal effect. They won't have legal effect, or they won't be operative until any appeals on that change are resolved. I think it's highly likely that they will get appeals. But my advice would be to not give or not attempt to give effect to those things yet until we have the final outcome. And you'd still be in the same situation where the amount of work that would need to be done to give effect to that change, that's too much work to do in the timeframes that we're currently working to. Just comes to Indigenous, what the change that is on itself, the NPS. So it's, yeah, they're trying to set similar criteria. Previously, they were a little bit out of sync.
Cool, thank you.
Any other members wishing to ask a question? No. Cool. Councillor Mitchell.
So just on that last point, we're basically following the operative version of the regional policy statement and imagining that the forthcoming changes aren't going to become operative in time.
The advice I've prepared is based off of the operative regional policy statement. However, I suppose the advice is that you don't implement this part of the regional policy statement because there isn't sufficient time to do it in a way that would, I guess, be good planning practice and do all of the engagement that would be required to identify those signs.
And in terms of SNAs, because I know that is a concern for our community, and just to be clear, we're not doing it, but there's a requirement in the operative regional plan and in the proposed changed a regional plan. Both have requirements for us to implement SNAs. It's just that the government may come over the top of that and say, we don't have to do it, not for 3 years at least.
That's correct. Both the operative and the proposed regional policy statement have a requirement for the identification of significant natural areas, but the central government is looking at pausing for 3 years the requirement to identify SNAs under the national policy statement. That wouldn't absolve the council of what requirements are set by the regional policy statement. So there would technically still be this requirement to identify SNAs under the regional policy statement, but it's impractical for council to undertake that task in the preparation of the proposed district plan.
And that did bring me to something I highlighted in your report, that you said regardless of the option adopted by council, there's very high risk that this part of it will get appealed. So do you think it's likely that we'll get appealed for not having implemented SNAs?
Short answer is yes. It will all depend on what happens to future changes over the next couple of years while the plan changes going through the process, about what central government does with potential changes to the Resource Management Act, what the Regional Council does with its regional policy statement, and how its appeals are resolved, and then what happens with the National Policy Statement on Indigenous biodiversity as well. If things stayed the way they currently are, I think it would be highly likely that there would be appeals on not including SNAs in the district plan. But it will all depend on how all of those other things that are currently moving all shake out.
Kia ora, Deputy Mayor Lewis.
Thank you. I'm just asking a question for Julie, who put it to us that she was concerned that Regional Council and Hutt City Council might be trying to take her land. Is there anything we could reply to that in this process?
In processes around changing the district plan, there's nothing involved in those processes about the transfer of ownership of land from one person to another, but I appreciate that. I think the point that the landowners are making is that it's not actually the transfer of ownership from one party to another. It's the tying up of the land through the regulatory tools.
Any final questions? No, I'll move on to the recommendations. I'd like to move that the committee notes the contents of the report, directs officers to prepare an ecosystems and Indigenous biodiversity chapter for the proposed district plan, under option 3, which is protection of Indigenous vegetation in residential zones, protection of Indigenous vegetation on public land in the natural open space zone, provisions to promote restoration and increase of Indigenous biodiversity, information requirements where resource consent is required for activities that have a more than minor impact on biodiversity, and finally directs officers to investigate a work stream that would ensure a district plan is updated to fully implement the requirements of the RMA, including MPS and the RPS for the Wellington region, noting that would be a separate plan change after this one. Do I have a seconder? Councillor Mitchell. Any members wishing to speak? Councillor Mitchell.
Yeah, I just wanted to speak to one element of it, which is the protection of Indigenous vegetation on public land in natural open space zones. I'm really pleased to hear officers' opinion that this delivers on Council's commitment of 2019, which is quite a long time ago, to protect those areas. And also just to reiterate once again, the need for mechanisms for voluntary protection and the advice that's been given before and given again today that probably QE2 covenants are the best method for that, but certainly happy for our council to explore if there are other opportunities to support voluntary protection of nature as well. Yeah, that's it for me. Thank you.
Kia ora. Any other members wishing to speak? I'll put the motion. All those in favour, please say aye. Aye. I declare that carried, noting Councillor Edwards didn't take part. Moving on to item number 6, I'd like to ask Sean Bellamy, our intermediate policy planner, to speak to the item. This is the update on rural zones and highly productive land overlay for the proposed district plan, which is on page 20 of our agenda. We've obviously read your report. Sean, were there any points you wanted to raise or any answers to any of the questions that were raised during public comment?
Yeah, thank you, Brady, for the opportunity to speak to this report. Firstly, I'd just like to apologise if I yawn. I've got a child that's just had surgery recently, so I'm a little bit broken my sleep at the moment. So it's not rudeness, I'm fully aware, I'm just a little bit jaded. So I'm happy to have the report as read. I would like to just address some of the points raised by landowners today, and also by Dan Jackson by email. So the key point I'd like to address is the highly productive land overlay. I've talked to several of the many of the landowners here about the highly productive land overlay, and I understand the frustration and the difficulties of having to work with that particular overlay. And the points raised about consultation and mapping and the process. Unfortunately, the mapping of the highly productive land is actually prescribed in the National Policy Statement for Highly Productive Land, and we don't have the ability to map that land. The mapping of that land is down to the Regional Council. We have to apply the map as it's been mapped in terms of category 1, 2 and 3 land use capacity, I think was the last word. We have to use the existing map for that. So that's where that comes from. And also the process in terms of Schedule 1 and the plan changes is a bit truncated as well. It basically says if we do a plan change, if we review our district plan, we have to incorporate the highly productive land. And the Regional Council hasn't mapped it yet, so we have to use that land that's already mapped as 1, 2 and 3. Having said that, the government has indicated that looking to change the National Policy Statement. And when they do that, we'll be in a position to do something else. So my understanding is they may remove category 3 land, which is, we don't have any category 1, 2 or 2 land. If they did that, then we could address that as part of this process later on. But my advice is that we don't have any real latitude to do anything in terms of that mapped area because it is prescribed for us. I am as well, we are looking into like the provisions for activities on those sites where there is highly productive land, to see if we can be a bit more enabling and see if we can, where we can fit with that. So we are looking at that as part of, between now and the proposed plan. So that's an ongoing process at the moment. that if there's any, I don't think I have anything else to add beyond that, if there's any questions.
Cool, thank you, Sean. There's definitely been some comments about interpretation, but this one is very clear, very prescriptive as to how it is mapped, and we have literally zero discretion as to how the mapping on it works. Am I right in assuming that if there is a change to the MPS on highly productive land as part of the proposed district plan process, noting it's quite a long period of time, that process would pick up any changes and throughout that plan change process?
Yes, so there's nothing specifically prescribed, but if they changed the national policy statement, as I've indicated they have, and it was before the hearing, you know, we can't, my recommendation would be, you know, if they remove category 3, would be to remove those maps from the maps, because there would be no need for it.
Thank you. And there was some reference to it in Dan Jackson's email and another speaker earlier that talks about, and I'm not entirely sure if it's related to this paper, so it may be one we've already covered, but you may still be able to answer about I'll just read it out. It has come to my attention that these overlays might enable Māori customary harvesting rights on my private property. Is that part of this overlay, or is this one earlier that I probably should have raised earlier? Cool, thank you, Nathan.
I'll grab Nathan to speak to that specifically.
Yeah, just to speak to that, it kind of cuts across a number of topics. It's not conferring any sorts of rights to anyone onto someone else's private property. The district plan never does that. What it's saying is if you know, is effectively mana whenua have access to a piece of land, whether it's land owned by mana whenua, or if it's public land that mana whenua have access to, or if it's private land where mana whenua have been invited onto the land, then the customary harvesting would be able to be undertaken in accordance with whatever the rules are of the district plan. It doesn't confer any rights for anyone to come onto private land.
Good, thank you for clarifying that. Were there any further questions, Councillor Mitchell? Sorry, Nathan.
Yeah, Nathan, just for clarity, does it override any restrictions and, you know, that are put in by different zoning or by anything else? Does that customary right override anything, or is it just guaranteeing access?
Sorry, can you repeat the question?
Sorry, it sounded like to me like it guarantees access to particular places. Does it override anything, any other restrictions in the district plan, and what can and can't be done in particular areas?
It all depends on how it's referred to in the district plan. It's effectively treated like any other activity rule, that you'll have a rule that says that customary harvesting will be a permitted activity or a restricted discretionary activity or something like that based on certain conditions. And if those conditions are met, then you're able to undertake that activity in accordance with what the district plan says. It doesn't treat the activity any different from any other activity. It'd be like earthworks or building a garage or a shed. It's the same thing that the district plan, just because it's got a rule saying that earthworks are permitted or building a garage is permitted, that doesn't provide anyone permission to come onto your land and do earthworks or build a garage.
Thank you. Thanks for allowing a slight crossover. I was trying to work out which one it's set on. Cool. Were there any other questions before we go to Councillor Simon and then Councillor Edwards and then Councillor Shaw?
Yeah, thanks, Sean. It's probably going to become a moot point if the government is going to remove the HPL on land use 3. But clearly there are some landowners in the room with the current mapping, GWRC mapping. They disagree that their land is LUC 3. Do you have some advice on, you know, how the GW reviews that, or do they have rights of challenge? What could you get? Anything you could tell them?
I'm trying not to go into too much detail, enough detail to be helpful, but not too much to be confusing. Essentially, because we're in the review, we've triggered the need to include the highly protected land in the district plan the regional council has an amount of time to map all the highly productive land in the district, which they've within the region, which they've started. And if that is completed, or when that comes to be done in this area, there'll be a chance for input into that. We're in a position, because we're reviewing the plan, we're required to include a mapped area, and we don't have a regional council map yet. So, so in terms of the mapping, in terms of district plan in this particular review, I don't have any kind of positive advice I can give on the mapping. What I could say is that assuming the government doesn't change the national policy statement between now and the new plan going through the hearing becoming operative, there is an opportunity to participate in the regional council process. The other position is that there will still be provisions for potentially doing things on your land that have have been identified as highly productive land. But those generally those activities like subdivision development are quite restrictive, because again the NPS is quite prescriptive on what it allows, and it doesn't allow a lot. So I haven't got a great deal of positive advice, unfortunately. I suspect, though, that the government has indicated it's looking to remove Class 3 land. So if they follow through on that, then presumably it won't be such a significant issue.
Thank you. Councillor Mitchell.
Yeah, just as a follow-up to that, you said restrictive in terms of subdivision and development, but one of the concerns we heard was about farming activities, for example, putting in tracks or fences. Is it restrictive in that regard?
Not the highly productive land. That's more the that more relates to the outstanding natural features in the coastal landscapes, rather than the actual highly productive land. It's set up for farming. It's just difficult to do much else.
Councillor Shaw, did you have a question?
Yeah, mine might be a little bit of a moot point, and you may have answered it. You did refer to the regional council maps. My question was about how old are those existing maps?
So I guess there's two things here. There's a national inventory for that classifies the land in New Zealand as Class 1, 2 and 3. That's what we're using. That's what we have to use for the district plan. The regional council has a separate process which is that's been brought into existence by the national policy statement, where it has to map all the soils and all the land in its area that is identified as highly productive land, and that's based on Class 1, 2 and 3 soils again. But that's a more consultative process. It's more a collaborative process. It just hasn't, as my understanding, it just hasn't had time to progress at this point, because it's not a district council process, it's with the regional council.
Thank you. Other members' questions? So we're not able to ask questions from the public during this process, but we're nearing the end of the meeting, so I'm sure we'll be able to ask questions then. No, I'll move on to the recommendations then. I'll move the motion that the committee receives and notes the report. Do I have a seconder? Deputy Mayor Lewis. All those in favour, please say aye. Aye. All against? I declare that carried. We've dealt with the next item, so we'll move on to District Plan Review Committee Forward Work Programme, which is on page 35 of the agenda. This one is pretty straightforward. Nothing has changed materially from the last time we saw it, and while not necessarily needed to be in here because this is an additional District Plan Review Committee, I thought it might still be useful having that Forward Work Programme in there just to outline which chapters are still to come. And the one thing I did want to highlight is that there aren't any further pieces of the chapters coming to this committee on the final sign-off. The final sign-off will be a cumulative of all the district plan. There won't be any additional last-minute chapters in that meeting to address. Did any members have any questions on the Forward Work Programme? I'll move the motion. I'll I've moved it. Do I have a seconder? Councillor Shaw. All those in favour, please say aye. All against? Declare that carried. Moving on to item number 6, questions. I've received no questions, so we'll move on to item number 10, closing formalities. We'll bring these up onto the screen. And please join along with me. Me karakia. So we all know it anyway. Unu here, e te uru tapanui, kia wātia, kia mama, te nāko, te tinana, te wairua e te aratakatu. Koe rā I rongo, whakahiaki ki runga, kia wātia, ai rā kua wātia, hau pai mārie. I declare the meeting closed at 11:42. Thank you, everyone.